Good morning. We're at the Los Angeles Law Library on Saturday, December 7th, 2013, and this is a Know Your Rights presentation. My name is Schoenberg. I'm an immigration attorney in downtown Los Angeles. In addition to my work as a private attorney, I'm also a volunteer attorney for the California Pacific Neighborhood Immigration Clinic of the United Methodist Church. CalPAC puts on immigration clinics and citizenship workshops throughout the Los Angeles metropolitan area. At those citizenship workshops and immigration clinics, we provide free immigration presentations, such as the one that you're going to see today. We also provide free individual consultations on immigration matters, referrals to free or low-cost immigration legal services providers, and for citizenship cases, we do actually assist with the preparation of applications for naturalization. So what we're talking about today is a couple of different things. The first thing that we're going to talk about is your rights when you're stopped or arrested by immigration, or when police officers or other law enforcement like the Sheriff's Department turn you over to immigration. We're also going to be talking about what will happen to you when immigration officers detain you and you either don't have legal status in the United States or you have permission to stay but you've done things or have other circumstances that can cause you to lose your status. So for example, if you're a lawful permanent resident, if you're somebody with deferred action for childhood arrivals, if you're somebody with temporary protected status or a non-immigrant visa and you've committed a crime or you've lied about your identity or about some aspects of yourself to get status, those are the kinds of things that can cause you to lose the status that you have. And we're going to be talking about your rights in circumstances in which you encounter immigration for one of those problems. So the first question is, where would you actually find an immigration officer? Most people do not volunteer themselves to immigration. Most people, encounter immigration officers at the home during a search of their home, for instance, at the workplace during a raid, or through an E-Verify program to ascertain whether you're lawfully allowed to work in the United States, at the border or the functional equivalent of the border, or in circumstances in which LAPD or the LA Sheriff's Department might turn you over to immigration through a program called Secure Communities. So the first question that a lot of people have is, what happens if an immigration officer encounters you on the street? Can they arrest you just for being in the United States illegally? And the answer actually is no. Only the federal government has the power to deport somebody who's in the United States illegally, not an LAPD officer, not an LA Sheriff's Department officer, or some other sort of public safety officer. In certain circumstances, an attorney general can choose to issue a warrant for somebody to be arrested for not having legal status, and that warrant is for somebody basically to be detained to wait for a decision on whether they should be deported from the United States, or to force that person to leave the United States if an immigration judge has already issued an order of deportation. However, a notice to appear for a hearing before an immigration judge is not the same as an actual warrant. All the notice to appear says is that you can be subjected to deportation for certain reasons, whether you enter the United States illegally or whether you committed certain crimes that make you deportable from the United States. And the notice to appear will give you a time, date, and place to appear for that hearing. But an immigration officer cannot issue you a notice to appear to arrest you for being in the United States illegally. Only if a warrant of arrest is issued by the Attorney General through an immigration officer can they take you in just for being here without papers. Now, there are certain circumstances where there are exceptions to that rule. Most of the time, they actually have to issue a warrant of arrest, but there are some times when an immigration officer can actually pick you up without issuing a warrant. If the immigration officer is at the border and they see you entering or attempting to cross the border without papers in their presence, like if they're literally seeing you in the binoculars, they can pick you up without a warrant. regardless of your immigration status, if the immigration officer has some reason to believe that you're guilty of a felony, in other words, a crime punishable by more than 1 year imprisonment that violates the immigration laws, and he or she believes that you would escape before a warrant is obtained, that is an exception also to the requirement that they get a warrant for your arrest for immigration purposes only. Now, immigration officers are, of course, different than police officers. Immigration officers are agents of the federal government. The agency is called U.S. Immigration and Customs Enforcement. They have different uniforms and different levels of authority. They're the ones that can actually pick you up for an immigration violation alone. A police officer cannot pick you up for immigration violations alone. The Supreme Court very recently, in a case called Arizona versus United States, said it is not a crime for a person to remain present in the United States without the permission of the U.S. government. A state or local law enforcement officer, like an LAPD officer, they cannot question, stop, or arrest you just for being removable from the United States, for committing civil immigration violations, in other words, being here illegally. And just because you're here illegally doesn't mean that you're involved in some other crime related to immigration, such as entering the United States illegally. Indeed, a lot of people come to the United States on visas, and they either overstay their visas or they have a problem with their visas. There are certain exceptions, though, where a police officer might gather information about you that causes you to be turned over to immigration. Those exceptions are consensual encounters with the police, if they stop you for another reason, like a traffic violation, if there's a formal agreement between the U.S. government and a local or state law enforcement agency to actually pick up people just for immigration violations, and other very, very limited circumstances authorized by the U.S. Congress. So what is a consensual encounter? A consensual basically means voluntary. Now that seems kind of like a funny thing to say when an officer approaches you, because it's not usually a voluntary encounter. You know, most people just don't hang out waiting to speak to a police officer on the street. But there is actually kind of a legal definition. So an encounter with an officer, a meeting with an officer, is consensual when a reasonable person, in other words, you know, somebody that, you know, an ordinary person living in that, encountering the officer, would feel free to refuse to answer the officer's questions, would feel free to end the conversation and to leave the scene. If you choose to speak with a police officer of your own volition, that officer may ask you about your immigration status. They may examine your identification documents, such as a California Department driver's license or a California identification, a consular ID. They may ask for a consent to search your luggage without any reason to believe that you're involved with a crime. Any statements that you make during a voluntary encounter with the police do not violate the Constitution. However, the officer cannot detain you beyond that very brief conversation just to confirm your immigration status. They can't ask you for any other matters other than what they stopped you for in the first place, unless they have probable cause to believe that you committed a separate crime. Under those circumstances, if you're stopped and you voluntarily engage in a conversation with the officer can only arrest you without a warrant if he believes that you've committed a crime in his presence, or he can detain you very, very briefly and frisk you for weapons if they reasonably expect that you've been involved in some other crime apart from being here illegally. Now, there are other circumstances beyond the consensual encounter, which, you know, again, is kind of a funny thing, where an officer might stop you for some other lawful reason. Usually these are things like traffic, you know, violations, if you're speeding, if you run through a stop sign, if you run a red light. Sometimes things like, you know, public drinking, loitering, you know, things of that reason. During those kinds of stops, an officer can ask for your name, they can ask for your identification, they can ask you where you're from. They can ask the federal government about your immigration status after you are arrested or cited for another crime without even having a formal agreement with the U.S. government. However, there are some limitations. They cannot prolong the stop. They cannot keep you around after the reason that they stopped you in the first place just to confirm your immigration status. They can't ask you questions about issues unrelated to the purpose for the stop unless they believe that you committed another crime apart from immigration. Your race or your ethnicity, Hispanic or Latino appearance, being in an area that, where there's a lot of immigrants is not really a lawful reason for a stop, arrest, or detention absent other evidence that you're involved with a crime. So as I mentioned before, there are some very limited circumstances where the federal government actually signs an agreement with a law enforcement agency such as the LAPD, giving specific officers the power to arrest people just for immigration violations. And there's a couple of circumstances in which that would occur. If there is an actual or imminent mass influx of people arriving off the coast of the United States or near a land border, they might have an agreement or ask local law enforcement to assist with arresting people, and that's kind of a very unusual circumstance. There have been some circumstances where people come in from boats off the coast of Mexico and they land usually in places near San Diego, although recently there was an entry, I think, near Newport Beach where that occurred. And in a circumstance like that, you know, ICE officers might ask like Newport Beach police to help and, you know, detain people. There are some other circumstances where state and local police can arrest non-citizens who were previously convicted of a felony, in other words, a crime punishable by more than 1 year in the prison, who were deported from the United States after that conviction. And that can only happen if state or local police confirms their immigration status or lack thereof with the U.S. government. And that person can only be detained for enough time for immigration to actually transfer them into their custody. There are other circumstances where, with the Attorney General's permission, a local or state police officer can arrest somebody for bringing somebody into the United States illegally. But in all of those cases, the state or local law enforcement officers must actually get training in immigration law, and they cannot arrest, detain, or stop somebody without the express permission and supervision of the U.S. government. There are other circumstances, though, where state, you know, where local law enforcement might work on a joint task force or help, you know, immigration officers enter county jails to inquire about people's immigration status. That also happens with or without an agreement from the U.S. government. So what happens if either an immigration officer or a police officer approaches you on the street? The state of California actually does not have a stop and identify law. You do not, as a matter of state law, have to give the police officer your name, your identification, and where you're from. There was a rule that was in place at least until 2009, and currently it's still in place, Special Order 40, which is a law that was issued to Los Angeles police officers telling them not to initiate contact with somebody based on their immigration status. If either an immigration officer or a police officer approaches you on the street, ask for their identification and the agency that they work for. There's a good chance that they don't have the authority to approach you based on your immigration status alone. If they want to detain you for violating the immigration laws, ask if they have a warrant that was issued by the U.S. Attorney General. Examine the warrant, make sure that it's signed by an immigration officer, that the warrant properly identifies you and lists the reason for your arrest just for immigration violations. Do not give that officer any reason to arrest or detain you. Don't run, don't fight with the officer, don't have any physical contact with the officer. Ask the officer if you are free to go. If the officer says yes, then walk away. Don't run or resist the officer in any way. Basically, don't give the officer a reason to stop you for further investigation. That's just the bottom line. So there may be also some circumstances where you see a police officer in a home, like either a police officer is assisting immigration and actually raiding a home or looking for somebody for their immigration status, or ICE actually comes to your home, usually at like 4 o'clock in the morning when everybody's sleeping. So law enforcement officers can come into your home and search it if they have a warrant, if they have consent to enter, or if there are exigent circumstances that excuse them from getting a warrant. Exigent circumstances are basically emergencies like fire, a risk of danger to persons or property, or a risk that evidence can be destroyed. So an arrest or a search warrant issued by a state court judge is different than the warrant of arrest that I mentioned for immigration violations. State or local law enforcement officers can get arrest or search warrants from a local judge. It's a piece of paper signed by the judge giving the police permission to either enter a particular home and search it or to arrest particular people in that home. And as I mentioned, there are two kinds of warrants: an arrest warrant that allows somebody to be taken into custody, and a search warrant that allows an officer to enter a particular place and identify or seize particular evidence. An arrest warrant does not allow officers to enter and search a building, and a search warrant does not allow an officer to arrest somebody in the home, an office, or a place of business. There are also things called administrative warrants of deportation or removal, which are issued after somebody has a deportation order. That does not give any police officer the authority to enter a building to do a search or make an arrest for immigration violations. So what happens if anybody comes to your home, whether it's immigration, ICE, whether it's LAPD? If they come to your home, don't open the door. Ask the officer through the door if they have a warrant. If the officers do not have a warrant, do not let them into the building. Do not answer their questions. Just tell them you don't want to talk to them and that you don't consent to them entering. If the officers do have a warrant, ask the officers to slip it under the door or to show it to you through a window in the door. If you must open the door for any reason, just open it just enough to grab the warrant and examine it, and then close the door behind you. Again, for a warrant from the LAPD or from the LA Sheriff's Department, look for the judge's name and signature, look for your name and address, the date and the place to be searched, a description of the items to be searched for and seized, and the name of the agency that's allowing the search to happen. If it's an arrest warrant, make sure that it, again, contains the judge's name and signature, your name and address, and the reasons for the arrest, and make sure that it describes you or whoever is going to be arrested in enough detail to actually identify you. So if it just says, I want to arrest a woman, that's not enough. You know, it actually has to have your name, and it has to describe you in enough detail to identify you and distinguish you from the other people in that room. If there is a mistake in the warrant, or if the search or arrest warrant does not contain those things, say that you do not consent to the search. There are circumstances, though, when the officers might force their way into the home. If that happens, again, state very clearly that you do not consent to the search. Do not give the officers, though, any other reason to arrest you. Just stand aside and watch them while they're searching. But do ask the officers to stay during the search and take notes about what things are searched and what things are seized in your home, so you can take further action. So sometimes there are circumstances where you're not just living in a home or an apartment or a house by yourself. Let's say you're living in a college dormitory, living in apartments with other friends, family, or roommates, renting a room in another person's home, or living in a multiple family dwelling, like multiple apartments with maybe one entrance. This is where it gets a little bit tricky because you don't always have the authority to just say yes or no, do you have a warrant? The issue tends to be consent. There may be circumstances where one of your roommates or like a dorm, resident manager consents to an officer entering and searching the building without you actually giving your consent. Or there may be circumstances in which your landlord allows the search of common areas of the home for other evidence of criminal activity. Now, consent does have to be validly obtained. Police officers cannot force consent to search a particular property. The person who allows the police to enter and search the property must have the authority to consent to that search. So for instance, if you have a party and you have 20 people at the party, not everybody at that party has the authority to let the officers in. Really only the person who owns or rents the premises has any authority over that search. And police cannot search the home with the permission of one occupant when the other resident is present at the scene and objects to the search. So if you have a roommate, let's say you live in an apartment with one roommate, and that roommate happens to be present and you happen to be present when the police show up, if you object to the search but your roommate consents to the search, the police cannot come in. They can't do it. The Supreme Court has said that that is not allowed. So there are some ways that you kind of can prepare for searches of your home if you are undocumented or you're concerned that law enforcement might encounter you. You can develop a plan with your roommates and co-tenants about how to respond to the police if they try to enter and search your home. You can designate a particular person to consent to the search of the premises if you happen not to be there. The police cannot arrest you in your home or someone else's home without an arrest warrant unless you're committing a crime, there's an emergency, or there's some other urgent circumstance. They can detain and frisk you for weapons while they're searching the home without getting an arrest warrant, but they cannot detain you beyond that. If police come into like a common area, for instance, of a dormitory, and you're in your individual room, shut the door. And make clear that you don't consent to a search of your own belongings. If the police officers insist on searching you anyway or searching your belongings, don't do anything to resist them or give any reason to arrest you. Do not provide any statements to the officer or sign anything. So as I mentioned before, police don't have to get a warrant to enter a home, to search the premises, or to make an arrest in another person's home if there's an emergency. There are some emergencies that qualify, but it kind of is a case-by-case thing. If there's somebody who's having a medical emergency in the home, police can enter it to administer assistance. If they're in hot pursuit of a fleeing suspect, police can enter a burning building, for instance, to put out a fire and investigate it, and in very limited circumstances to prevent evidence from being destroyed. But if the police want to do that, they really have to show a compelling need of somebody, like an imminent danger to person or property, and that they have no time to get a warrant. If there is some time to actually get a warrant before they do the search, they can't just run in. So there are circumstances, as I mentioned before, where you might encounter immigration or police officers in the street or in your home or in somebody else's home. Frequently, many undocumented people or people with immigration status may encounter police and immigration actually at their workplace. Two of the most common circumstances in which you might come into contact with immigration are during a raid of your workplace for undocumented people, or through an e-verify system, which is kind of a computer database verifying your right to work legally in the United States. ICE or LAPD or LA Sheriff's Department can enter areas of a business that are open to the public. So for instance, a reception area of an office, a public area of a store, a lobby of an office building. If that area that you're in is not open to the public, they need either a warrant, there needs to be an emergency, or the business owner has to consent for that officer to enter. Police cannot arrest somebody without a warrant at work unless you're committing a crime in their presence, or unless there are exigent circumstances, in other words, an emergency like the ones that I described before. You can be detained briefly and be frisked for weapons during a raid of a workplace, and there are certain industries where government agencies can conduct administrative inspections, like a nuclear reactor, in circumstances like a chop shop where there's a lot of previous illegal activity without any warrant or any other reason to believe that anybody's committing a crime there. Again, if immigration raids your workplace, don't do anything to arouse suspicion. Don't do anything to give anybody a reason to believe that you're involved with a crime. Keep your California driver's license, your California ID on you at all times. Do not carry with you fake documents or foreign documents such as a matricula or a passport, because those can be seized from you. You do not have to give the police officers a statement or respond to their questions. Do not sign anything, don't give any statements, and give as little information about yourself as possible. I mentioned before that you might come into contact with immigration through an e-verify search, which is actually an internet-based search that compares information on an immigration form called an I-9 form with Social Security or Department of Homeland Security databases. And the whole purpose of E-Verify is just to confirm whether you're authorized to work in the United States. So an employee will complete the I-9, the employer will enter the information into the E-Verify system, and that gets compared against the records of the federal government. The federal government will indicate whether employment is authorized or whether there is a tentative non-confirmation, in other words, no match with a person who's allowed to work in the United States. If your name does not match federal records, you will be asked to either go to the Department of Homeland Security or the Social Security Administration for an interview so you can verify your right to work here. If the mismatch is resolved, then E-Verify will send a message to the employer saying that you can stay in your job. If there is no match, E-Verify will send a final non-confirmation result and the employer has to terminate you. So not everybody's on the E-Verify system, only federal contractors and subcontractors and certain private employers who elect to be on the E-Verify system are on it. States can punish employers who violate E-Verify requirements, but they cannot require a private employer to be on the E-Verify system. In fact, in California, the state of California said that no city or town can force a private employer to actually be on E-Verify. So another circumstance where you might actually find somebody from immigration is if you're at the border or the functional equivalent. A border is more than Tijuana. It can be a land boundary or crossing between the United States and Mexico or Canada, like the normal pedestrian lanes or car lanes. There are checkpoints on roads leading away from the border, such as the San Clemente checkpoint. There are intersections of 2 or more roads leading directly from a border crossing and international airports. Most searches at the border don't require any warrant or any reason to believe that you've committed a crime. The officers can search your car, your belongings, and ask you questions about your right to enter the United States. They can examine your identification. Any prolonged detention or questioning beyond a routine customs inspection, which usually consists of some basic information about your immigration status, looking at your identification documents, and examining your car, that has to be supported by at least a reasonable suspicion that you're involved in some other sort of crime. But for most people, unless they're referred to what is called secondary inspection, any search or questioning is not going to violate the Constitution. There are other circumstances, too, where immigration officers are not at a fixed checkpoint, but they basically patrol an area within 100 miles of the border. These are commonly called roving patrols, and they're usually consisting of Customs and Border Protection officers from the border. CBP officers, in those circumstances, they can pull people over to the side of the road. They can stop people at convenience stores, gas stations, and public places near the border. They can detain you if they reasonably suspect that, for instance, your car contains people who are here in the United States illegally. But a CBP officer cannot stop or detain you for just violating a traffic law like an LAPD officer can. If that immigration officer wants to detain you after brief questioning and a search of your car, they must either have the consent of the driver or some probable cause to believe that the car contains unauthorized people or contraband, like illegal drugs, for instance. Immigration officers near the border can enter private lands, but they cannot enter houses or the area immediately around a house without any sort of consent or a warrant. So if you're stopped by a Customs and Border Protection or CBP officer at the border, give that officer, again, as little information as possible, only your name and identification as requested. You do not have to consent to questioning by the CBP officers in secondary inspection, for instance. Beyond brief questioning about your permission to stay in the United States, do not sign anything. Ask for a lawyer before you sign any statements. So the final way that you would probably encounter an immigration officer is through the Secure Communities Program. The Secure Communities Program is a deportation program that was started by the Bush administration and continued under President Obama. It's basically a program where U.S. Immigration and Customs Enforcement takes people from county jails and state prisons into their custody for deportation hearings. And under that program, what will happen is an LAPD officer, for instance, will turn over the fingerprints of anybody that they arrest to immigration. If immigration believes that that person is undocumented or otherwise deportable, they will issue what is called an ICE hold, through which LAPD or the state prison has to hold somebody in detention for about 48 hours until immigration can pick them up. That is only supposed to be a 48-hour period of detention. However, because state police agencies typically have not allowed people out on bond beyond that 48-hour period, a lot of people end up actually staying in custody for up to like 20, 30 days while they wait for immigration. The average in LA is actually 20 days. So there are some problems with the Secure Communities Program, which you probably heard of. A lot of the LAPD and LA Sheriff's Department officers do not want to do immigration enforcement. It causes people to become very afraid of the police and not to cooperate with them when they investigate or charge people with other crimes. And then of course if someone is deported and their family members left behind, a lot of children suffer, from, for instance, having their parents be deported. It's a very expensive program, and it's a program that is very broad. The whole purpose of the Secure Communities Program was to catch dangerous individuals and deport them from the United States, but the vast majority of people turned over to immigration through Secure Communities have never been convicted of any crimes, have minor crimes or crimes that were long ago, or their victims of mistaken identity, or they've been rehabilitated. More than half the people deported under the Secure Communities Program in California had no criminal history at all. So, the Secure Communities Program in LA started with a memorandum of understanding in 2009 between California and ICE. In 2011, California passed a bill to modify that memorandum of understanding by requiring local communities to affirmatively choose to be part of the Secure Communities Program. In December of last year, both the LAPD and the LA Sheriff's Department said that they would not honor any request by immigration to turn over people who are convicted of certain low-level misdemeanors. What that means is a case that requires less than a $5,000 bail in the state court, for instance, drinking in public, sidewalk vending, possession of drugs. And actually, in October of this year, the state of California Assembly passed something called the Trust Act, which was signed by the governor of California on October 5th. And that law, the Trust Act, prohibits police from detaining somebody based on an immigration hold after that person becomes eligible for release from a state prison or county jail unless certain conditions are met. So those conditions basically involve somebody being convicted of a serious or violent felony, a felony that is punishable by a sentence in state prison, or certain serious misdemeanors such as sexual abuse, child abuse, theft, robbery, burglary. Some examples of crimes that would not trigger detention for immigration purposes would include misdemeanor driving under the influence, drug possession, petty theft or shoplifting, or perhaps selling food on the street without a permit. So, there may be circumstances where immigration may ask state or local police to hold you if you're stopped for a traffic violation or some other reason, and if you fit into one of the exceptions for further detention under the Trust Act. An ICE officer may come to you in a county jail or in a state prison and interview you. They may ask that you be turned over to an immigration detention facility when you serve your sentence. If you're turned over to an immigration detention facility, an ICE officer is required to make an initial bond determination. In other words, they're supposed to decide whether you can be released from custody pending further hearings on whether you should be removed from the United States. So first, the immigration officer will consider whether there are certain bars to you being released, and usually this boils down to what kind of criminal history you have. If you have a conviction for what is called a crime of moral turpitude, for high-speed flight, for a drug possession even, you can be held in custody for the entire time that you're in immigration hearings. If you don't have any of those criminal arrests or convictions, then the immigration officer will decide whether you would flee or be a danger to the community if you're released. If immigration issues a bond, your family can go to downtown Los Angeles to a building about 2 blocks away from here and pay the bond, and you'll be released from custody. If the bond is too high, you can either go for an immigration bail bondsman, or you can ask for a hearing before an immigration judge for a bond redetermination. In other words, reconsideration of the bond amount. During these initial encounters with the immigration officer, frequently immigration officers, either in a state prison, a county jail, or even when you initially come into immigration custody, they may approach you and ask you to stipulate to your removal. What that means is that you agree to be removed from the United States without seeing an immigration judge or having any opportunity to contest your deportation. If you sign one of those stipulations, it is a conclusive determination of your deportability. A judge has to review that form to make sure that you voluntarily signed it, but other than that, there's no other review of your case. 1/3 of all removal orders these days are actually stipulated removal orders, and according to Stanford Law School, the vast majority of those removal orders are obtained from people who have very limited English speaking capabilities, who don't have an attorney, and who are detained. A lot of people do not realize what they're signing under those circumstances. The usual scenario in which this occurs is when an ICE officer approaches you and said, if you sign this now, you'll get out of custody. If you don't sign this, you're going to be held for months or years while you wait for an immigration judge. Whatever the immigration officer says, just don't sign any statement. Even if they say it will be easier for you or you'll get out sooner, they're not telling you the truth. You're basically only going to get out to be deported from the United States, and that's a very severe consequence for most, if not all, people. If you are detained by immigration, you do have the right to remain silent. Anything that you say can be used against you in either a criminal case or in immigration proceedings. Some immigration offenses like illegal re-entry or alien smuggling are also crimes. So if you make a statement pertaining to your involvement in those actions, that can be used against you to both deport you and also to hold you in jail, in a federal jail. You do have a right to an attorney at no cost to the government. In most cases, you have a right to hearings before an immigration judge before you can be deported. If immigration denies your request for bond, of course, you can ask the judge to review that bond again. And the immigration judge in those circumstances will look again to see if you have criminal history that bars you from being released, or if you're going to flee or be a danger to the community if you are, in fact, released from custody. If the immigration judge denies the bond when you come into custody, originally of immigration, and when your deportation hearings begin, that's actually not the end of the matter. You can still qualify for another bond 6 months after your deportation hearings start if you're still in custody, and if it's not likely that you're going to be deported in the near future. So do keep that in mind if you're denied bond by an immigration judge in the first instance. It's a pain to wait for 6 months, but a lot of people have gotten out of custody that way. So again, if you're detained by immigration, do not speak with the officers, do not answer questions without a lawyer or without having a lawyer present. Tell them that you want to speak to a lawyer. You can even hand them a Know Your Rights card or memorize an attorney's name or phone number to give them. Do not give a statement or sign any papers without talking to an attorney. Do not accept a voluntary departure, in other words, an agreement to leave the United States at your own expense and on your own instead of being deported without talking to a lawyer, because a lot of times voluntary departure does not allow you to come back into the United States. Try to get the identification of the officer who's detained you. Again, these officers might really press you to give a statement or to respond to questions, but don't respond. It's not going to make things really easier for you. So, you know, a lot of you might be wondering how to actually get an immigration lawyer. That might be why you're actually here, to consult with a lawyer. Even though you do have a right to have an attorney present with you during questioning, and you do have a right to actually have an attorney assist you with your immigration case, immigration or the U.S. government does not have to actually provide that lawyer for free. There are some attorneys that do provide pro bono, free or low bono, low-cost services. If you are detained, you may be contacting a lawyer, or you may actually have family members contact a lawyer for you. There are certain ways that you can find a lawyer for your case. You can attend a legal clinic like the one that you're at right now. You can contact the immigration section of the LA County Bar Association or another legal referral service authorized by the State Bar of California. There are some nonprofit organizations that have lists of private immigration lawyers, such as Carecen and the Esperanza Immigration Rights Project. If somebody is hiring a lawyer for you, though, make sure that that lawyer is licensed to practice law in California. You can check the State Bar website for California lawyers. If that lawyer is not licensed to practice in California, find out where they are licensed and check the State Bar website. Ask the lawyer for their credentials and for their experience in immigration matters. So, a lot of people have had trouble with notarios or people lying about lawyers, defrauding them. It's important for you to know that there's only certain people that can actually represent you on an immigration case and who are qualified to give legal advice to you. And those people are attorneys who are licensed to practice in any state in the United States. There are BIA accredited representatives who undergo pretty rigorous training and who, you know, do hundreds of hours in immigration law to learn how to represent people either on a green card application or naturalization application or even in an immigration court. But they're specifically approved and designated by the BIA to help in immigration cases only. There is a list of BIA accredited representatives on the Executive Office for Immigration Review's website. In very limited circumstances, another reputable individual that has a pre-existing relationship with you can represent you with the consent of an immigration officer, for instance, during an asylum interview. I really don't recommend that, because just because you happen to have a friend who's helping you out doesn't mean they actually know what they're doing in an immigration case. And of course, law students working under the supervision of a licensed attorney can also represent you. Most importantly, though, outside those categories, you may have heard of immigration consultants, immigration assistants, immigration specialists, notarios. These people are not lawyers and cannot represent you before immigration or before any court of law. There's actually a very specific category in the state of California called immigration consultants. These are non-lawyers who provide non-legal immigration assistance. Now, what does non-legal immigration assistance mean? It basically means that they can fill out forms, they can put the answers to questions on the forms, they can help clients get supporting documents for those forms, such as birth certificates for a green card application. They can mail the forms to U.S. Citizenship and Immigration Services, and they can refer cases to immigration lawyers without a fee. However, an immigration consultant has to post a $50,000 bond with the state of California in order to do any business in the state, and that bond's actually going to increase next year to $100,000. They must provide a written contract to every client outlining the services to be performed, the cost of those services, and stating explicitly that they are not an attorney. They cannot give any legal advice. They cannot tell you what to put on the immigration forms. They cannot give you any legal advice on immigration matters at all. They cannot accept fees for referring your cases to other immigration lawyers. They cannot demand any advance payment for fees for services that might be provided under a comprehensive immigration reform bill if Congress ever passes one. They also now, as of October 5th, 2013, cannot literally translate into English terms like notary public, notary, licensed attorney, or lawyer, or any other phrases that would imply that that particular consultant is an attorney. Notarios are not immigration consultants, and they're not attorneys. These are basically people who lie about their legal credentials or lie about being in business with a lawyer. Do not hire a notario, an immigration consultant, an immigration assistant to represent you. They are not an attorney. They cannot give you any legal advice. They may say that they work with a lawyer or they're in business with a lawyer. Do not believe them and do not hire them, because lawyers cannot be in business with non-lawyers. They cannot exchange money. So, there are a lot of circumstances where a notario will basically bring in the business and they'll sign up the contracts and fill out the forms, and then they'll hire an attorney to be at appearances in the immigration court. That's actually illegal. A lot of attorneys have gotten into trouble for that, and a lot of clients usually get into a lot of trouble for that because, of course, the attorney's not prepared to represent them. So, just be very, very wary of those situations when you go to a lawyer's office. Make sure that the attorney is actually present and you're meeting with the attorney and you're not just meeting with a notario, and it's not non-lawyers that are basically running the show. Ask a lot of questions about the structure of the office that you're actually hiring to represent you. So you do have rights to hearings before an immigration judge in most circumstances before you can be deported. The only exceptions to that is if you're detained at the border and you're subjected to an expedited removal order because you don't have a right to come in. If you enter the United States under something called the Visa Waiver Program, which is for people from certain countries, usually in Western Europe, to enter the country for 90 days without a visa, if you were deported previously and re-entered illegally, or if you have certain kinds of serious crimes in your background, such as aggravated felonies. In removal hearings, otherwise known as removal proceedings, you have a right to have an attorney of your choice represent you at your own expense. You can confront evidence and witnesses presented against you. You can present evidence and witnesses on your own behalf. You can refuse to testify if your testimony would link you to the commission of a crime. If you do have a criminal record and an immigration officer approaches you in custody, do not accept any order of deportation or voluntary departure without talking to an attorney. Particularly with aggravated felonies or very serious crimes, that's a very technical definition, and there may be circumstances where you qualify for other relief that you don't know about. So if you have any criminal history at all, it's just really, really important to talk to an attorney before you go forward. But I think the most important thing for you to know, just generally about your rights in these circumstances, it's much better to protect your rights earlier rather than later. In criminal cases, you can actually exclude from evidence anything that was obtained in violation of your constitutional rights. That doesn't always apply in immigration. Only certain egregious violations, in other words, things that an officer should know violate the Constitution, can be left out of an immigration court hearing. Immigration judges typically are not very good at excluding evidence under these circumstances. So just don't count on an immigration judge to protect your rights for you. Protect your rights at the beginning, by not giving statements that can be used against you. You can always challenge evidence or statements later as being unreliable, but it's just very, very hard to do. So that's, basically the end of my presentation. If you have any other questions, please let me know. If you don't, you're welcome to come to our clinic and our citizenship workshop, which should be starting or have already started. Thank you.